This podcast is brought to you from the lands of the Turrbal people. We also acknowledge the custodians of the land that you're listening from. Before listening further, please be aware that this podcast deals with information, descriptions, and words relating to sexual violence. It's not suitable to listen to around children, and you may well find it causes distress. You might choose to listen to it somewhere where you're comfortable and you feel safe, or even listen with a support person. Reaching out for support is an extremely brave thing to do, and help is available. You can call the Sexual Assault Helpline on 1800 010 120 between 7:30 in the morning and 11:30 at night, 7 days a week. Or call Victim Connect on 1300 318 940, 24 hours a day. Both services have specialist counsellors who'll always listen and believe you, and you can remain anonymous if you like. Hi, I'm Kay McGrath. You might recognise my voice as I worked as a journalist in Queensland for many years. Through that role, I've had the privilege of meeting people like you, people who've experienced and survived trauma. Hearing your stories has inspired my work outside journalism, and it led me to get involved with the Daniel Morecambe Foundation and Act for Kids. I'm also a patron and co-founder of Protect All Children Today. I co-chaired the Queensland State Government Domestic and Family Violence Prevention Council that was established by Dame Quentin Bryce as a result of the Not Now, Not Ever report. And I'm also a founding member of Women in Media Queensland. This podcast has been developed by the Office of the Victims Commissioner in collaboration with many people who work with and advocate for victim survivors of sexual violence. Thank you to all of our contributors. This podcast has been recorded for victim survivors of sexual violence, family members or friends supporting them, or people who work with people who've experienced sexual violence. We often hear that for victims of crime, it's hard to find the right information at the right time. It's difficult to understand the processes which you may have to go through if somebody has hurt you. You'll have to meet and talk to people you've never met before. They'll use words that you may not have heard before. But I believe strongly that having information from somewhere you can trust will help you make decisions about what is best for you. Before we begin this episode, I'd like to take a moment to acknowledge that this is a difficult topic, but I want you to feel safe as you listen to this podcast. You can listen on your own, you can listen with someone you trust, you can listen at your own pace, all at once or in parts. And of course, you can listen as many times as you want to. I think it's important that we begin by acknowledging something bad has happened to you or is happening to you. There's nothing that I or any of the other contributors on this podcast can say to undo the hurt that's already been done. Please know the information included in this podcast is to help you seek help or report the violence. It won't take the place of professional support from experienced and qualified support workers or legal advice from lawyers. And let's acknowledge that you may feel nervous or scared. Dealing with the police and the courts can be scary and frustrating. I think it's important we understand the legal system in Queensland is built on processes, not on personal experience. It's important to remember that victims all have different experiences and stories, which can leave people feeling like no one understands their hurt or that no one is listening to them. Your experience of hurt may have been caused by someone you know, someone you've had or are still in a relationship with. You may not have even realised that you've been hurt until you shared your experience with someone else. You may have been very young and not understood what was happening to you. You may have blocked it out, tried to forget because remembering is just too painful. Your trauma may have led you to make decisions that you might not have made otherwise. You might have used drugs or alcohol to manage your feelings. Regardless, we hear you, and there is a network of support services who can help you. We have a Victims Commissioner in Queensland. The Victims Commissioner is an independent role and separate from government. The Commissioner provides advice to government about how things can be done better to meet victims' needs. You can visit the Victims Commissioner website to learn more about the Charter of Victims' Rights, which are rights for victims of violent crime in Queensland. Today, we're talking about issues that victim survivors of sexual violence might find helpful if police charge someone and the survivor needs to go to court. And we're joined today by Queensland's District Court Chief Judge, Brian Deveraux, and also Liz Kelso. Liz is a consultant Crown prosecutor from the Office of the Director of Public Prosecutions. Chief Judge and Liz, thank you very much for making the time to join us today.
Thanks, Kay. Hi.
Thanks, Kay.
In our previous episodes, we've spoken with support workers about where victim survivors can go following an incident of sexual violence. But today, let's talk about what happens if you need to go to court as a witness. Now, I'm sure you'll agree with me that the court process can be intimidating. It can be overwhelming for a lot of people. And I remember when I was reporting as a journalist, it was often challenging to know all the processes and to make sure that, you got everything right. There are a lot of terms and words that are used that we're unfamiliar with. So perhaps let's start with you, Chief Judge. Can you tell me exactly what the Chief Judge of the District Court of Queensland does? What's your role?
Oh, well, my role is to be responsible really for the court's administration. What that really means is, we have 43 judges in the District Court. 15 of those judges are permanently based outside Brisbane, the rest of us in Brisbane. And we also go on circuit to many other places in Queensland. So the Chief Judge's role is really to make sure that the conditions are right so that the judges can do all that work.
Right. So you're in charge?
The head of a jurisdiction is often referred to as first among equals.
We're focusing on sexual violence today. Can you explain how sexual violence matters are dealt with in the District Court?
The whole process starts with the presentation of a document called an indictment where the charge is written down. And it's really an important document because it's a public document that says by a prosecutor, the DPP, with all the force of a prosecutor, I'm alleging this person's committed a serious offence. If a person is charged with an offence, a sexual violence offence, and pleads not guilty, there'll be a trial, almost always with a jury. But if the person pleads guilty, there won't be a trial, it'll just be a sentencing proceeding, which is a really short proceeding. On the way to that, there are often pre-trial hearings or discussions, might be an argument about what the evidence will be or how a witness will give their evidence, that sort of thing. So there's a number of steps.
On average, I know this is a difficult question, but on average, how long does the criminal justice process take for the victim of a sexual violence assault?
It varies widely, of course, but starting from the magistrate's court and going through that and allowing time for the DPP to prepare the case to present to the district court, going through the district court to a final result, that could be about 18 months, probably at a minimum, more likely to be over 2 years, up to 3.
And that's being realistic, isn't it? That
Yes.
the justice can be slow.
It can, but there are a lot of steps to take along the way.
Yeah. So, but people should be aware of that and they should prepare for that.
They should. It can be much shorter if the defendant enters a plea of guilty once it gets to our court, the district court. But if it's going to go to trial, that'll take some time to prepare and get to.
So there's quite a process before the actual trial or case can actually begin.
Yes.
There's a lot of work has gone into that. Let's bring Liz into the conversation and just establish your role, Liz, with the Office of the Director of Public Prosecutions. That sounds like a hefty title. Can you break that down and explain what it is?
So our office is responsible for all of the prosecutions that occur in the District Court and the Supreme Court across the entire state of Queensland. It is a bit of a mouthful, so often our office will just be referred to as the DPP, which of course just breaks down that Office of the Director of Public Prosecutions.
And when you say that the DPP is responsible for all the cases, what do you mean by that?
So all of those serious crimes that must be dealt with in the District Court and the Supreme Court, they're heard in those more superior courts, and our office is responsible for taking them through that process. As distinct from traffic offences and public nuisance offences, which are some of the matters people might be familiar with being dealt with in the Magistrates Court.
And the majority of those cases come to you through the police department?
That's right. So once the police charge someone with a criminal offence, they'll prepare a brief of evidence, and then that brief of evidence, that is how we prove that the crime occurred, will be given to our office. And our office is made up of lawyers and prosecutors who are responsible for analysing that material and preparing what are the appropriate charges to proceed in either the District Court or the Supreme Court.
So a complaint has been made about a sexual assault. It's investigated by police and they forward their findings to the Director of Public Prosecutions or the DPP, and you look at that case and decide whether you can proceed with it or not.
So police will take a complaint made by a victim of sexual violence and they will charge that person if they consider they have sufficient evidence and put together the evidence that they say will help prove the crime. And having put all of that evidence together, it'll be potentially statements from witnesses, it can be recordings, various other physical evidence, and then they will give that to the prosecuting agency. Often that will be the Police Prosecutions Corps, but on some occasions might be our office. And the matter first takes a journey through the Magistrates Court before it ends up in predominantly the District Court for sexual violence offences.
So sexual violence offences often begin in the Magistrates Court or always begin in the Magistrates Court?
Always.
And what makes it proceed to the District Court?
So once police have put together the evidence they say is necessary, then the person who's been charged with the offence will have the opportunity to consider that evidence. Sometimes there can be a hearing in the Magistrates Court where people are required to give evidence, but not always. And once that court is satisfied there is sufficient evidence that can go towards proving that charge, those sexual violence offences will be elevated at what's called a committal to the District Court. And that's really where our office then steps in.
Right.
And it's after that then that the higher court, the District Court, comes into it.
Thanks for explaining that process. And I'm wondering, Liz, before we come back to the Chief Judge, the DPP, the Director of Public Prosecutions, do you provide any sort of support or liaison officers for people who have to go through this process?
So once a matter comes to our office, one of the very first people that a victim of sexual violence will hear from our office is our victim liaison officer, or sometimes shorthand called a VLO. That person is a contact person and provides consistency for a victim of sexual violence to be able to relay information about what's happening with the court process, and in addition can help provide referral services if that person doesn't have sufficient support around them to help take them through that journey.
Good to know, and I'd like to expand on that a little bit later. One question I've got here is, are all sexual violence cases heard in the District Court? Can any be elevated to a higher court?
Almost all sexual violence cases are heard in the District Court. Some can be heard in the Magistrates Court, but not if it's going to be a trial. If the person pleads guilty, some can be dealt with there. Also, though, a sexual violence offence might end up in the Supreme Court if there's another charge, which is a Supreme Court charge, like a homicide or a certain level of serious drug offending. So if a person's charged with that kind of offence and a sexual violence offence, they'd all be heard together in the Supreme Court. Otherwise, the District Court is the place where we have the jurisdiction to deal with all of these offences.
Right. So these cases often begin in the Magistrates Court and are elevated, as Liz said, to the District Court. Now, Chief Judge, are these cases in the District Court heard by a jury? We often hear about a judge-only case. How does that work?
The starting point is everybody has a jury trial. It's in the law that a person can apply to have a trial just by a judge. And it's pretty rare, which I think, if I may express a personal opinion is a good thing, because I think one of the great strengths of our system is the jury, because you have people brought in from the community who don't know each other and who absorb material and have to make a decision. It's a really good exercise in democracy. That's why I say almost all trials are jury trials. But there can be an application for a judge-alone trial.
What would be an example of that? Why would that application be made?
Perhaps I can answer it with an example I've had. I heard a trial without a jury one time where there were so many charges that I think it was understood or thought that a jury might be overwhelmed by the material. Also, the accused in that case, the defendant, had videoed a whole lot of material, a whole lot of the acts with the complainant, with the victim. So there were hundreds of hours and hundreds of charges.
Just too gruelling.
And it
perhaps
seemed unreasonable to put a jury through that, particularly because the issues were fairly narrow. There was no dispute that the events had occurred. The dispute was a different issue about whether the defendant might have thought that the complainant was consenting, for example. So the application was made and a judge made that ruling that it should be a judge-alone trial. That's a pretty extreme case, but judge-alone trials are a minority, a small minority.
Liz, can I come back to you before we move on and explain more about the whole legal process? We've already heard a term guilty plea or not guilty plea. Can you expand a little bit on those definitions?
So as part of our role, most people charged with these type of offences will be represented by a lawyer. You'll hear the term solicitor and barrister. That's just another specific role within the field of being a lawyer. We will talk to them. They will take instructions from the person charged and they will advise whether they accept that they did what we're alleging that they did. And if they accept those facts that we say make up the charges, then we'll go to court and that person will be asked, how do they plead? And they'll say they're guilty, which means they accept what we say they did. If they don't accept what we're saying, then they will be asked how they plead. They will say not guilty. And ordinarily we're told what the specific issue is. So often there might be issues around consent, or they say things occurred differently to what the victim says or has explained has happened. With children, they might suggest that they thought they were older than they were. There'll be a whole raft of issues, and normally we know what in particular they're disputing. And that's something we can engage with a victim about depending on the circumstances.
Just briefly, you mentioned a solicitor and a barrister. What's the difference, and would a sexual violence survivor need to hire a barrister?
So that's our role as the DPP. So I'm a prosecutor at the DPP. So my role, whether a person pleads guilty or not guilty, my role is to present to the court the evidence and the facts of the crimes that we say that person has committed. And if that person has said they're not guilty of the crimes, as a prosecutor, which is effectively a barrister but who works for the DPP, and will present the case accordingly. We're those people that you see walking around with wigs and long robes and looking a little bit like we're out of a Harry Potter movie. The solicitors, or in our office, they're called legal officers. They're the ones who will come to court and instruct us, and they have the day-to-day management of your file if you're a victim with our office.
Thanks for clarifying that. So if somebody is faced with this prospect, they have to go to court, it's their first time ever in a courthouse, it can be a rather overwhelming experience, a lot of new experiences. What sort of support is there for people before they go to court?
Our office will have many conversations with a victim throughout the life of a file in our office as the matter starts and through to its conclusion. A lot of those discussions will involve inquiries about what support that victim already has in place. They might have support from friends and family, and they feel already properly supported, that they don't want to engage with any external networks. If someone doesn't have that benefit or wants some additional support, we'll provide referrals to the Queensland Sexual Assault Network, who have a number of different agencies across the state who are able to provide extra support outside of the court process and during it. Then there are court support network agencies that our office engages to help support a victim through the process potentially in a more practical way. People within those agencies will come with the victims to our office for conferences, support them in terms of going to court with them. They can sit in the courtroom with them while they give their evidence and be more heavily involved. And then our office on top of that will support victims by having pre-trial conferences, explaining the court process with them.
Right. You've mentioned pre-trial conferences a couple of times. That means coming together and sharing information, perhaps explaining the next steps. Is that what you mean by conferencing?
That's right. So we will have already spoken to a victim to say and explain that a person has perhaps said they're not guilty and the matter's going to trial before a jury. We'll arrange for that person to come into our office, sit down with them, talk them through practically what the court process involves, what they can expect in terms of giving evidence, and perhaps more importantly speak to them about how they might give their evidence and what that looks like for them in terms of putting up proper supports.
And we'll talk more about how they might give their evidence during this conversation. So Liz, when a victim enters the legal process, when are they required to appear in court?
So I think we've discussed already that a person accused of the sexual violence crime will be asked to plead guilty or not guilty. If that person has said or indicated that they'll be pleading not guilty, then we go to a trial, usually before a jury. That process will require the victim to come along and talk about what happened to them. And then during that process, they'll also be asked some questions by the lawyer who's representing the person accused of the crime.
But if the offender pleads guilty, what happens then?
Then the victim won't be required to come to court, but of course they may come to court and watch the sentence hearing if that's something they would like to do. And we also sometimes have the opportunity for that person to listen to the proceedings via telephone link or via a video link if they'd like to watch that person be sentenced but can't physically attend the courtroom on that day.
There's a lot of jargon and there are a lot of terms used to describe people who've been sadly affected by sexual violence. How are they referred to when they reach the criminal justice system, Liz?
So we use a lot of different terms to describe people accused and victims of sexual violence or any crimes for that matter, in the same way that we describe barristers and solicitors and prosecutors as counsel and lawyers and all different terms. We might use the term victim or complainant interchangeably depending on where we're at in terms of the court process and what's happening, but it really means the same thing. We're talking about the person who's been affected by the crime. And personally, the more important process for me is really to call that person by their name because they are a person who's involved in this process, and it's important to me that no one loses sight of that.
It's really heartening to hear you say that. And in one of our earlier episodes, we pointed out that the criminal justice system is based on processes. It's a system and it's one that we have to abide by. So to use a person's name is reassuring, I'm sure.
The object of the trial is to decide whether the offence was committed by the defendant. And that's why we use the word complainant, which means the person who says an offence was committed against me. The person who's complaining that there was an offence is referred to as the complainant, always at that stage of the proceedings. The language can change after a finding of guilt or a plea of guilty, so that often enough when a judge speaks to a defendant in sentencing, the judge will refer to the victim. In fact, will speak to the defendant and refer to your victim.
And the defendant is the person who perpetrated the
crime. Who's committed the offence. By that stage, you might change that language too, and it's the offender.
Yeah.
Or in old times, it was called the prisoner.
So their guilt has been established, and then the terminology, the words change to the convicted or to the offender and the victim.
But as Liz says, there's an increasing use of people's names.
Which humanises the whole process too, which is what we're trying to do in this podcast. You mentioned people in the courtroom. Can anybody from the general public wander into your district court and sit down and listen to a case?
Yes, courts are open. The starting point is we have an open justice system. Anybody can come. And quite regularly we have people just come to look at courts, school groups to come and look at courts.
And to observe the criminal justice process in action. When would it be necessary to close a court?
In a sexual violence case, the law requires that when the complainant is giving evidence, the court is to be closed. What that means is the term that we use is all inessential persons are excluded. So the essential persons are the jury, the accused person, the witness, the lawyers, the judge, the judge's associate, the bailiff, somebody who sits next to the defendant from corrective services. In other words, the people who are necessary to make the process happen. Inessential persons are excluded. That's what closed court means.
So those school children would be asked to leave?
Oh, yes.
Definitely.
And recently the law was changed a little to confirm that when an interview, in certain cases, particularly with children, when the police speak to the child and effectively take their statement, that's done by recording it on video. And then that statement, that recording is played in the trial. So that now, when that is played, the court is also closed.
And to just restate here, also media is invited to leave the courtroom as well, so they can't report on any of that. So journalists have been asked to leave the court as well when it's closed. Let's talk about what can be reported from the district court in a case like this and whether or not media can identify the victim of sexual violence. Liz, can I come to you first? Can you explain the rules around reporting of these cases?
So it's really important that we protect a victim in terms of this process. So there's a strict prohibition against reporting the identity of a victim involved in a sexual violence matter, and that might have an impact on what even a reporter can release about what's been happening in court, because sometimes the person who's committed the offence might have such a relationship with the victim to even report any of it might risk identifying the victim. Having said that, a victim's empowered that if they want their name released, that is something that they can choose to do, but that is always their choice. Otherwise, they'll be protected throughout the proceedings.
It's up to the individual, which is why the system is good. It protects people, but it allows the person to speak out if they want.
Every victim is different and wants to participate and wants something different out of the court process. So we will support them, whatever their choice is, but experience dictates everyone's choice is different because they come with their own unique experience.
Absolutely. And we all respond and react so differently to events that happen to us.
There are a lot of measures that we can put in place to support victims of sexual violence. They are from a starting point. The courtroom is closed, so no one outside of the necessary people and, more importantly, supporters of an accused person aren't allowed to be in the courtroom while they give their evidence. They're entitled to support people, to support them throughout the process. We can put them in a separate room so that they can't see the accused or put a screen up in the room. We can control what type of questions are asked of a witness. They can ask for breaks throughout the process, and certainly improper questions will be prevented throughout the hearing.
What are some of the other words that we might hear in a courtroom, Liz?
I think probably one of the biggest ones is the word arraignment. We'll often talk to victims or families who are supporting victims that the matter's listed for an arraignment. That just means that the court will be asking the person accused how they plead to the charges, whether they plead guilty or whether they plead not guilty. And even in court, the prosecutor will ask the judge, can you please arraign the defendant? And that's all they're being asked to do, is tell the court whether they're guilty or not guilty of the crimes. Often we make the mistake of using shorthand terms such as 590AA or 21AK. That can just refer to sections. What that means is, for example, a pre-trial hearing. So sometimes the lawyers will want to argue about what type of evidence goes into a matter, how evidence is heard, and so the lawyers will have a legal argument before a judge who will decide those matters, and we call that a pre-trial hearing. Then a pre-record is simply where that particular victim has chosen to be supported in a way that their evidence is recorded before a trial, and so we call that a pre-recorded hearing because that's where we record that particular witness's evidence and then we'll play that evidence in the trial itself.
So there are options available to the complainant or to the victim survivor, and these will be explained before the criminal process begins.
So we will always engage with a complainant who needs to give evidence in a trial about what it looks like for them giving evidence. And again, everyone's expectations and concerns can differ. So we have some who are adamant that for them, giving evidence is them giving evidence in the courtroom with the lawyers and the judge and the jury, because they want to be able to look at the person who's done this to them, and they want them to know that they have the strength to be able to speak about that in that forum. That's not the case for everyone. Some people don't want to see that person, understandably so, and so there are steps that we can take to ask the judge to put measures in place to support them. That might look like a screen that stops them being able to see the person in the courtroom, giving evidence from a remote location. We have the benefit of courts throughout the state, so it might be that if our complainant's in Cairns but the trial's in Brisbane, they give evidence remotely from the Cairns courthouse through to the Brisbane courthouse, or we have remote rooms within the courthouse. We'll talk to them about what support looks like for them as well. Do they need a support person with them? Who that person might be. It can be a court agency. It can be a social worker or a friend, depending on the circumstances. It's all about what it looks like for that person in terms of how they can best give their evidence to the court. And everyone's concerns are unique, but the benefit that we have is everyone is entitled to the courtroom being closed. That's automatic. So no one else outside of those necessary will ever hear the evidence of that person. And I know a typical concern we have is friends or family of the defendant or offender being present to be able to hear that, and they will always be excluded from the courtroom.
Right, because that could be very intimidating. So, and there are rights for people who've experienced this violence. We've spoken earlier about the Charter of Victims' Rights. So is this part of what you're talking about here, Liz?
It is. We have an obligation to speak to our complainants about how we can best support them through that process of giving evidence in the court. But in terms of the actual measures that can be asked for and put in place, that's all legislated. So there's laws around that. And there's applications that our office will make to the judge hearing the matter about what this person needs to be able to give their best evidence to the court and why we need those measures. Because an important thing at the moment is that it's up to a judge to decide whether those measures are appropriate. So we can ask for them, and it's up to the judge to decide whether they're appropriate or not.
I know personally that there is an organisation called PACT, which stands for Protect All Children Today. And I know that you are a fan of their work. What sort of support do they provide to the people who are unfamiliar with this whole court process?
From the judge's point of view, the people from PACT are really important because very regularly now the complainant in a sexual assault trial will give their evidence not in open court but from a remote room so that we'll see them on a video, and that might be recorded before the court day. We call it a pre-recording. People from PACT regularly attend and sit in the room there as a support person with the witness. And from what I understand, PACT assigns that person to the witness early and they go through the whole process together. So it's not just the part that judges see.
Yeah,
so
there's a real relationship.
There's a relationship that develops. It's a really valuable organisation.
And we should point out that PACT now also supports adults through this legal process. PACT offer highly trained volunteers who can stay with you and often with your family and help provide a constant support over what can be a long period of time. They'll explain the process and they'll be a familiar face to walk alongside you. And when you say a remote room, that's probably within the court building, isn't it? But it's just not having to be physically present in a large, often intimidating courtroom.
Yes. And the arrangements are such that the witness can only see the person who's asking them a question. They don't have to see the defendant, but the defendant must be able to see the witness. So that's all right. That's how that works. Also, when that evidence is being taken, the court's closed, which means, and it's a good thing to be able to tell the witness that the court is closed, which means there's no members of the public in court.
Or media.
Or media. Only the people who have to be there because it's part of their job to make the process run.
And how would that make a witness feel?
Well, hopefully that makes the witness feel slightly more comfortable about delivering the information. The good thing about having them in the remote room is that they're not sitting in a public room with 12 strangers, the jurors, and all the people around them looking at them. So the witness feels more comfortable about delivering, probably for the third or fourth time, what to them is a really traumatic story.
Yeah, absolutely. It's sad, but it's a fact that people have to over and over again recount, as you say, what's happened to them. So any sort of supports, reassurance that we can put around them, I think, is invaluable. So we've got the pre-trial conferencing, which is where a person is kept up to date with how the case is proceeding. We've got organisations such as PACT who can work one-on-one with people who are going through this process and explain further. We've got various other victim support services, and of course people can and often will have hopefully accessed counselling before they get to this stage.
There's a Charter of Victims' Rights, which also addresses things like information that a victim is entitled to. And that can include information about whether the defendant has bail or is applying for bail. And it allows the victim then to tell the prosecuting authorities, whether it's just the police at that stage or the DPP, whoever's involved, whether they have any concerns about the person getting bail. And if the person's going to get bail, what conditions should be imposed to reduce those concerns.
What about people who might need even more support in the courtroom? For instance, English is not their first language. What supports are in place for them?
If the witness needs an interpreter, there'll be an interpreter, although the interpreter is usually provided by the party calling the witness. So in this case, if it's a prosecution witness, it'll be for the DPP to organise the interpreter. But if it's a defendant, it's for the court to organise that.
So we'll organise, again, and often we'll know this as well because we liaise quite heavily with the investigating officer who has had a lot of contact with a complainant in the matter, having been responsible for charging. So between our conversations with them and the victim themselves, we'll identify any extra supports and arrange interpreters. They can be Auslan interpreters, people with particular learning disabilities or mental health illnesses. Again, we liaise with and talk to psychologists, speech pathologists, counsellors about other measures that we might put in place to make sure that person is best supported to give their evidence in the best way possible.
Okay, so the process is underway. What happens once all the evidence has been heard?
At the end of all the evidence, both sides have the opportunity to speak to the jury, or if it's just a judge, to the judge, and make submissions about the evidence to try to persuade the jury to whichever outcome they're seeking. So the lawyers, usually there are lawyers, address the jury. And after that, the judge sums up to the jury. What that means is the judge tells the jury so much of the law as they need to know to make the decision. Sometimes tells the jury how you may and may not use certain types of evidence. And in a very brief way, overviews the case, the arguments for each side, to try to help the jury make their decision. But the jury makes the big decision, which is whether the defendant's guilty or not guilty.
And we often hear the term, the jury retires.
Oh, yes.
What's that mean exactly?
The jury goes into the jury room privately to discuss the matter. That's all it means.
They retire from the courtroom and they all get together and discuss, under your direction, the evidence that they've heard.
Yes.
So once a jury retires, how long does that process normally take before they come back?
It can take an hour or two. It sometimes, but rarely, takes much less than that. More often it takes longer, particularly because we often have recorded evidence, that police recording I mentioned, as well as if there's recorded evidence in court, the pre-recording of the witness. Sometimes the jury want to see those again, and so we reconvene court and they do all of that. We watch all of that again. then they go back into the word we use is their deliberations, their discussions about the case. So, a jury might start their deliberations after lunch one day, but they might well go home at 5:30 that night and come back at 9:30 the next morning and keep going.
And Liz, you mentioned before the VLO, or the Victims Liaison Officer. What is their role at this stage of the case? Are they keeping the victim survivor informed?
So it's usually at that stage, it'll actually be the prosecutor who's been conducting the trial will be in constant contact with the victim in terms of explaining where we're at in the trial and what's happening. It's quite difficult, as the Chief Judge said, in terms of once they go out to consider their verdict, a jury can take any amount of time before they come back with their verdict. So a question and a discussion usually centres around, does the victim want to be present when they return their verdict? And if they do, often that will require them to be at or around the particular courthouse from the moment the jury steps out to start considering whether they'll find the person guilty or not guilty. Because once a jury says they have a verdict, we all have to, as the lawyers, be back at that courtroom quite quickly because the verdict is then taken from the jury almost immediately.
So again, that can be another stressful part of the whole process, is to hang around and wait for the jury to return and deliver their verdict. Can anybody enter the court at this stage to hear the verdict?
Yes.
Yes.
Anybody. You mentioned it could be stressful for the complainant or the victim. Do they have to be in court? Could they ask somebody else to be in court for them? Could they phone you and find out the result? What are their options there?
There absolutely is a lot of options available for a victim. They are welcome to have anyone else they might like come along in their place to watch the verdict, whoever that might be in terms of their support, regardless of whether they're there or not. If obviously the victim's there themselves, once the verdict's been returned, the prosecutor involved in the trial would have a conversation with you about what that was and what that means. If you weren't there to be able to hear it, again, the prosecutor who's been conducting your trial will get in contact with you as soon as reasonably practical once court stops to tell you what that verdict was and, again, explain what that means in a practical sense.
And again, we should restate that this is a right under the Victims' Charter.
Absolutely. And in fact, the experience should be that that prosecutor has spoken to you. You will have had many conversations with that person throughout the trial. And so we will have conversations with you about how it is that you would like to be told about the verdict as well, because some people like to make sure that they're not driving home from work at the point in which the jury's return their verdict and they've got proper support around them. That's really important to us as well, to make sure they're properly supported in receiving that news, because it can be really stressful regardless of what the result is.
Yes, of course. So what happens next if the offender is found guilty?
If the defendant is found guilty by the jury, often enough we proceed straight to sentence, because the parties, the prosecution and the defence, should have anticipated or been ready for that. Everybody should be ready to make their submissions about what the sentence should be, and we will proceed straight to sentence.
And when you say submissions, Judge, you mean suggestions?
Yes, arguments.
Arguments.
Maybe that's the word. Both sides will present arguments, and that might involve a discussion of what the facts were, because all we know from the jury is guilty, not about particular facts that they agreed with or didn't agree with. So the factual basis for the sentence, and then information about the defendant from both sides, and information about what the range of sentencing for this kind of offence is. And the court hears from both sides, and then on the spot usually will sentence.
Sometimes you don't sentence immediately. You would go away and reflect on what was appropriate?
A couple of things might happen. The good thing about the sentence proceeding straight away, if everybody's ready, is that particularly for the jury, they can come back into court and watch that. And that's really, I think, a valid thing to happen. They've taken part in the trial. They've invested their few days. Trials don't go very long generally. They might only go 2 or 3 or 4, maybe 5 days. And occasionally we have longer trials in sexual assault cases. But the jury's invested that time and come to the result, and they get to watch what happens after their verdict. But for whatever reason, perhaps one of the parties wants to get a report prepared. Perhaps the victim impact statement isn't ready yet and the victim wants time to put that together. Or it's late in the day and it'll be adjourned off to another day.
victim impact statement. What exactly is that? And does everybody need to submit one or write one?
The victim impact statement is a statement of the harm caused to the victim by the offence. And no, the victim doesn't have to write one, but it helps the judge because the law requires the judge to take into account the effect on the victim. But also understanding the effect on the victim helps the judge to understand the seriousness of the particular offence, the nature of the offence. And that's one of the primary considerations, one of the primary things the judge has to take into account when deciding what the sentence should be. The prosecutor really has power. Liz might want to answer this more than I, but the prosecutor has power about how to use the victim impact statement.
The preparation of a victim impact statement and what that might look like is a conversation that will start quite early on in the piece with the victim liaison officer and will be picked up by your trial prosecutor in preparing you for trial.
It's a written document. It's been shown to the other side and the court has it. And that's what enables the judge, when sentencing somebody, to speak to it, speaking to the defendant about the effects of their crime on the victim.
Does it go against a person if they choose not to provide an impact statement? Does that lessen the impact of what's happened to them?
No, it doesn't. In fact, the law is against that inference. There's a specific provision in the Penalties and Sentences Act that says to the effect that the absence of a victim impact statement does not mean you infer there was no harm. The benefit of the victim impact statement is that it informs the judge. The judge is not entitled to speculate. Of course, as human beings, we're allowed to proceed on the basis that these acts no doubt had a certain kind of effect, but we can't guess about it because we have to sentence the defendant for what has been established against him or her, not what we think or might think.
And we often hear about people reading their impact statements to the court, but you've mentioned it can be handed up in written form, so it's not necessary to actually stand up and read that impact statement.
More likely people will give it to the prosecutor and, of course, the victim might not be there at the sentencing, but they can read it out or they can have the prosecutor read it out. The one thing that people might not know about the victim impact statement is it's a statement addressed to the court, to the judge, not a statement addressed to the offender. So,
what do you mean by that? So what's the difference?
It's the opportunity to say to the judge, this is what's happened to me as a result of what they did. But it's not an opportunity to look at the defendant and say, you did this.
And explain
I think this about you. I wish this would happen to you.
And will the offender hear or read that impact statement at some stage?
Usually they're given to the defence before the proceeding so that their lawyer will take them through it. And as I said, very often the judge will actually refer specifically to it. If not quote from it, then at least speak to the effect of it when sentencing the offender.
And Liz, I'm thinking the public can also read that impact statement.
So it won't be made available to the public, but certainly if there were members of the public or media outlets who were present at the time of sentencing and either the prosecutor read the contents out or the victim read it out themselves, and inevitably the prosecutor will make reference to parts of it regardless, and so will the judge in sentencing. Those, of course, will be heard by those people present in the courtroom.
Is there, Liz, any limit on how long a person can work on their victim impact statement if they've chosen to give one? Will they be under pressure to provide it to the court?
So we'll explain as part of particularly the trial process or if things are listed for sentence, what a victim impact statement is, what it might involve, the fact that it is effectively a letter to the judge hearing the matter about the effect that the crime has had on you. We'll often explain that our job is to tell the court what happened in terms of the crime itself, but that document, that victim impact statement, is really useful to talk about the impact it has had on a victim from the point in which the crime has happened. That can also include their involvement in the trial process. Sometimes there might be some time impediments on it, and it's certainly something we need before a sentencing hearing, and often I'll explain I need it by the time the jury start to go out and consider their verdict because we don't know how long they will take.
Okay, so what help is there if I need to get that impact statement to you? Who can help me do that?
So our victim liaison officers have a lot of helpful fact sheets about how you might provide one. I know PACT can assist for those that they're supporting. I often say as well, There's no right or wrong thing for a victim to put in their victim impact statement. They shouldn't feel constrained, because then that's a conversation I can have with them afterwards about why we'll tell the court certain things and not other things. But they shouldn't feel pressure to prepare a victim impact statement. It's their document. And then it's my job as the prosecutor to help make sure that the appropriate information is put before the court. And those are conversations that we have with the victims so they know what's being told to the court and why.
If the victim impact statement's not ready after a verdict of guilty, that's a fair reason not to proceed straight away with the sentence. And I would expect the judge, if asked, to delay the sentence so that they can be prepared. Because the victim impact statement, the default position is there will be a victim impact statement, and it would be a rare case where you said, we'll go ahead without one if the victim wants to present one.
Yeah, they have a voice. And tell me, what support is available if an offender is found not guilty?
So obviously that's a conversation that we'll have with the victim after the trial has concluded, if that's the decision of the jury. We have referral services available to a large number of support networks. We will often have already had a conversation with someone before the verdict's returned to make sure that they're prepared that of course can be a result, and what that might look like for them in terms of making sure that they have the proper support around them for what will inevitably be an incredibly upsetting result, having gone through that journey.
Yeah, and a long, lengthy process. Liz, any other messages or information for somebody who's going to court for the first time as a victim of sexual violence?
I guess the biggest thing is don't be hesitant to reach out. I tell victims there's nothing worse than them sitting back and stewing over questions that they feel too afraid to ask, or often they don't want to feel like they're being a bother to our office. I say to them, please ask. That's what our victim liaison officers are there for. And if they can't answer the question, they have access to the legal officer and the prosecutor who are looking after your matter, and we will sit down with you or talk to you over the phone, whatever suits you, in terms of answering those concerns, because they're much better dealt with rather than having you stress and concern over something that we can perhaps answer or deal with. It's important to us that we give you all the information you need to feel like you're supported and strong enough to go through that journey.
And it can be a long journey. Chief Judge, any particular information you think would be valuable for our listeners?
I think sometimes victims feel that everything's weighted for the defendant, because the defendant is treated like the most important person in court. But you see, from one point of view, the defendant is the most important person in court, because the defendant is charged with a really serious offence, and if he's or she's found guilty, they're going to go to jail. And so we have a system, and when we talk about a fair trial, we really primarily are talking about a fair trial for the defendant, because that's the person with actually a lot to lose in this trial. But we also mean a fair trial for all of the witnesses. And in a broader way, by doing that, we mean a fair trial for the community. But it's understandable if victims feel like everybody's worried about the defendant. But there's a very good, proper basis for that.
Yep.
Just sometimes hard to explain.
Everybody has the right to be treated with respect and dignity. It's a very challenging process to have to go through.
We've talked a fair bit about the process, including in the trial, but one of the judge's jobs is to make sure that all witnesses are treated respectfully. In a prosecution of a serious sexual offence, the complainant, the person who says this offence was committed against me, is for the prosecution the most important witness. So if you come to trial, if you come to court to give evidence, you're entitled to be treated with respect. And it's part of the judge's job to make sure that you are as comfortable as you can be in those circumstances, and that the questions asked of you are not improper. And, for example, if you need a break, you can ask for one. There's no time limit on your evidence. The judge might put a time limit on cross-examination if it's getting too long and it's repetitive. But you can take as much time as you like in court to tell your story, and you can expect to be treated properly. It's the lawyer's jobs to ask you clear, proper questions. And it's part of the judge's job to make sure that's done. So you should be able to come to court expecting that sort of fair treatment.
Thank you very much, Chief Judge, and thank you, Liz, for sharing your expertise and explaining what can be a long and often complicated process. You've really shed a lot of light on the whole journey. So thank you both.
Thank you.
Thank you.
Victims of violent crime in Queensland have rights. You're a victim if someone has hurt you. You've experienced sexual violence. You're a victim of domestic and family violence. Someone has killed or hurt someone in your family. You were hurt because you helped someone when they were being hurt. These rights are outlined in the Charter of Victims' Rights. Government and government-funded agencies that work with victims of crime must uphold the Charter of Victims' Rights. The Charter has different rights at different stages of the criminal justice process. Throughout the entire process, you have the right to be treated with respect and dignity, to have your personal information kept private, and to be informed of support services and options. You have the right to make a complaint if your rights aren't upheld. When police are investigating, you should be told about the investigation. You should be told if someone gets arrested. If the case goes to court, you should be told when court meetings are, be provided information about whether the person who hurt you applies for bail, and if you have to be a witness in court. After court, you should be told if the person who hurt you goes to jail, and you have the right to information like how long they'll be in jail. You can read the Charter of Victims' Rights, including an easy-to-read version in 8 different languages, at victimscommissioner.qld.gov.au, or ask the service working with you for a copy. If the person who used sexual violence against you was someone you were in a relationship with, a family member, or someone who's caring for you, you might be experiencing domestic or family violence. Support is available for people experiencing domestic and family violence. You can talk to police or talk to a support service. Police or support services can help you apply for a domestic violence order. A domestic violence order is a legal document. It tells someone not to hurt, threaten, coerce, or scare another person they're in a relationship with, or were in a relationship with, or a family member. The order tells someone to follow rules like stay away from another person or not let children see or hear violence. If you're in immediate danger, call 000. And if you'd like more information or support, call 1-800-RESPECT on 1800 737 732. I hope you found this episode informative and useful. In our next episode, we'll be talking to Queensland Corrective Services about victims' rights when an offender is sentenced to prison. Feel free to keep listening, or if you need to take a break and come back later, that's fine too. This content can be distressing, so please remember to take time and speak to a trusted friend or a counsellor, and always check in with yourself. Take care, and I'll speak to you soon.